What is a statement of claim? Today, I'm going to be explaining what this important document is and what it means in your lawsuit. I'm Natalie Gerry, the principal lawyer and founder with Gerry Law. I help injured people get the compensation they deserve for their injury. Let's get into this. What is a statement of claim? So this is the official starting point of most lawsuits in Ontario. Think of it as the blueprint of the case. It's the document that sets the wheels of the legal process in motion by outlining what happened, why it matters, and what the plaintiff, the person who's filing the lawsuit, is asking for in compensation. So whether you've been injured in a car accident, you've been injured in a slip and fall, or you face some other form of harm, this is the key document that brings your grievance into the legal arena and officially starts your lawsuit. So the first thing to consider is where to file the claim. Before filing the statement of claim, you or your lawyer must decide which court has jurisdiction over your case. Claims of $35,000 or less go to small claims court, and claims involving larger sums, so more than $35,000, are handled by the Ontario Superior Court of Justice. For cases under $200,000, the simplified procedure streamlines the process and makes it faster and less costly in theory. Once the appropriate court is determined, the statement of claim is filed within the applicable limitation period, and generally that is 2 years from the date the harm was discovered, but sometimes other limitation periods apply. It depends on your situation and the cause of the harm. So what is inside a statement of claim? The statement of claim is a highly structured document. It begins with the title of proceedings, which names the parties involved, so the plaintiffs and the defendants. For example, if you're injured in a car accident, you might name both the driver and the owner of the vehicle as defendants. If your family members have suffered losses, like the loss of care, guidance, and companionship, they too can be included as plaintiffs under Ontario's Family Law Act. And I do have another video that goes more into the Family Law Act claims and what can be claimed, and that will be linked below. The heart of the statement of claim is divided into sections, so it's in numbered paragraphs, and those sections include, first of all, the prayer for relief. So this is the summary of what the plaintiff is looking for, such as damages for pain and suffering, lost income, medical expenses, or other compensation. Importantly, the dollar amounts are listed are strategic estimates. They're not exact calculations of the losses, so it's not a mathematical equation. It's more of a guess as to what the damages might be at this stage. The more exact figures come in later, but these figures ensure that all potential outcomes are covered, including the worst case scenarios. So usually the numbers that are in the statement of claim are the upper limit, so the worst case scenario, and they want to cover all of the potential damages that you might suffer. Another important element is the description of the incident. So the claim provides an account of what happened. So in a slip and fall, then it will describe the circumstances surrounding the event and also the location where it happened. The description is typically broad at this stage. It doesn't include evidence. It gives more of an overview about what the facts are, and it leaves some room so that the facts can be refined and details can be provided later in the process. The third thing that it does include is a description of the injuries or losses, and again, this will be in broad terms. It won't be evidence. There won't be medical records. It will be an outline of how the plaintiff has been affected, including physical injuries, emotional distress, financial losses, and any impact on the plaintiff's family. The fourth thing that will be contained in the statement of claim is allegations of negligence. So this section will identify what the defendants did wrong. For example, in a car accident case, the defendant might be accused of distracted driving, speeding, or being impaired. And lawyers often will include a wide range of allegations to ensure that they can go through and ask questions about every possible angle during during the discovery phase of the lawsuit. Because the statement of claim is sort of the parameter for what the lawyer can ask about in discoveries, things will be alleged just so the lawyer can determine if that actually applies at the discovery stage. So you might be wondering, why is the statement of claim important? The primary purpose of the statement of claim is to notify the defendants of the case and its basis. So it must be filed with the court, and it must be personally served after it's issued by the court. It has to be served on the defendants, usually within 6 months, although sometimes extensions can be granted depending on the circumstances. Once served, the ball is in the defendant's court. They must respond with a statement of defense outlining their position and disputing the claims made against them, or they can pay the claim, but most times they're filing that statement of defense within the time frame allowed by the court, which is usually 20 days. But normally, if there's a lawyer appointed, they will have to look into things, and it may take longer than 20 days. An interesting tip, so behind the scenes, some lawyers don't share the statement of claim with their clients. And the reason for this, it can be a strategic decision, because if the client hasn't seen the claim, then they can't be cross-examined on its contents at trial. So this can reduce the chance of being caught off guard during questioning. But some lawyers do ask their clients to review the claim, especially for the facts, so that their client can review the facts and make sure that everything is correct. And it is important that the facts going in are correct, although later they can be refined and more detail can be provided. So you might be wondering then, what happens next? So after the statement of claim is served and the legal process is started, both sides then exchange evidence. So after the statement of defense. So then questions can be asked of both sides in discovery, and ultimately the sides look to prepare for a resolution of the claim, and whether that's through settlement negotiations, mediation, or through a full trial. So in essence, the statement of claim is more than just a piece of paper. It's the foundation of your case, and it ensures that your voice is heard and that your rights are protected in the legal system. If you have any more specific questions, then I can be contacted at the information below, and I will be happy to discuss them.